Governor Beshear won a round in the U.S. Supreme Court today. The High Court will allow his executive order mandating virtual learning to apply to religious schools. Some schools and the Attorney General argued it violated the First Amendment. LEX 18's Catherine Collins explains why attorneys for the schools are claiming a small victory too.
The order from the Supreme Court today means Governor Beshear's inclusion of religious schools in his latest round of executive orders can stand, but the timing of this decision is important.
This is in no way were religious schools treated any differently. We asked everybody to make the same sacrifice. Everybody, every school, not picking on anybody, just asking everybody to do the exact same thing.
In November, the governor announced multiple restrictions to slow the spread of coronavirus. One of them required all schools, including religious, to be virtual only through the end of the school year. A suit brought by Danville Christian Academy and Attorney General Daniel Cameron claimed this mandate violates the constitutional rights of religious schools. Today, the Supreme Court sided with the governor, noting that his order is set to expire soon, with no indication it will be renewed.
Governor Beshear is not going to be able to do this again. We're going to have to wait and see what he decides to do.
Hiram Sasser is Executive General Counsel for First Liberty Institute, attorneys for Danville Christian Academy. He says this decision means if Governor Beshear decides to issue a mandate impacting religious schools again, it could likely return to the Supreme Court.
It's a great path forward for us and for religious liberty. It depends on what the governor wants to do starting January 4th.
He says they'll be ready to fight once again. Governor Beshear maintains religious schools were treated like all Kentucky schools. Earlier this week, he released guidelines for schools to reopen for in-person learning in the new year. Catherine Collins, LEX 18 News.